Hello and welcome to our webinar today. My name is David Carter and I'm a member of the Faculty of Law and Justice at the University of New South Wales and a member of the Health+Law Research Partnership. Today we are hearing from two colleagues, Dr. Anthea Vogl and Vikas Pawani, about migration and migration law for people who are affected or living with hepatitis B. Anthea and Vikas are part of the Health+Law Research Partnership that works to understand legal issues facing people living with hepatitis B in Australia, including those who are migrating to this country. Migration, as you I'm sure know, is a complex and lengthy process for most people. But for those living with or affected by hepatitis B, the process and the journey can often be more complex than most. For this reason, we want to share some information about Australia's migration system and its processes, as well as some specific supportive information about hepatitis B and migration law as well. So today, to begin, I'll introduce Dr. Anthea Vogl, who will present first, followed by Vikas. Dr. Anthea Vogl is an Associate Professor of Law at the University of Technology in Sydney. Her areas of expertise are refugee and immigration law. Anthea runs the Clinical Refugee Law Program at UTS and is currently co-leading national grants on community refugee sponsorship in Australia and the legal needs and health requirements imposed on non-citizens living with the bloodborne virus. She's an Associate Co-Director of Border Criminologies at Oxford University and author of the book Judging Refugees, Narrative and Oral Testimony in Refugee Status Determination, which was released in 2024. Anthea is going to speak to us today about refugee and migration law in context, and I'll hand over to her and then come back and introduce Vikas thereafter. Thank you, Anthea.
Thanks so much, David. It's lovely to be joining. And I will just share my screen before I get going. So it's great to be here presenting to you today on Australia's migration law system. And I will start my presentation, like any good lawyer, with something of a caveat, which is essentially to note that this is a very high-level presentation and an overview, for the most part, intended for a non-legal audience. I will not be drilling down into the finer details of migration law, which is broadly impossible in the next 20 minutes. Instead, what I will do is give you a sense of how the pieces of Australia's migration program fit together. This will help you understand the streams of migration and general visa classes open to non-citizens, which in turn will dovetail into how the health requirement and waiver operates that Vikas will focus on very shortly. Roughly what I'll be covering today are really 4 topics: Australia's migration program and migration advice, migration streams and statistics, the permanent and humanitarian migration pathways, and then temporary visa pathways and their challenges. To give you a sense of the visa categories and their breadth, there are well over 100 classes of visa in Australia, and not only are no 2 of them the same, but the process for applying for a particular visa and the criteria that must be fulfilled, the documents and proof the applicant must present, all of these things for each visa category are highly specific and complex. As well, part and parcel of migration law in Australia is a vast, regularly slow and commonly overwhelming bureaucracy, which David intimated as part of the introduction. This bureaucracy governs the reception and assessment of an application, and this, of course, occurs at the departmental level, so at the Immigration and Citizenship section of the Department of Home Affairs. Australia's immigration law is governed by the Migration Act 1958 and the Migration Regulations, along with a range of important non-legislative policies. In applying for a visa, the failure to meet what might seem to be a very minor or trifling administrative requirement can lead to the rejection of an application out of hand. That is, without considering its merits. I say all of this in the introduction to highlight really 2 themes that will run through my presentation today. The first is the highly technical, opaque, and bureaucratic nature of the field, and the fact that it is non-citizens seeking a migration status really of any kind who must both navigate and experience this particular kind of bureaucracy and legal system. There is always asymmetry in legal advice giving, especially to clients who have no understanding of a particular system that they are operating within. but it's especially sharp in relation to migration advice. This quote from the Law Council of Australia gives you a little sense of that complexity. They note that by its very nature, immigration advice predominantly involves people with a limited knowledge of Australian law and of administrative and legal procedure, often with limited financial resources, and often with limited proficiency in the English language. This is a very high degree of information asymmetry in migration matters, which is something to bear in mind both as lawyers and people dealing with those who are seeking to migrate to Australia. This underscores, I think, an important related point that even the filling out of a simple form in the area of migration law is almost impossible to navigate without dedicated and expert advice. A fact that gives a clear sense of the complexity of migration law up until now is that a number of years ago, those of us qualified as just garden variety lawyers could not, by virtue of that qualification, provide migration law advice, such as assisting a person with a visa application or a visa cancellation at the departmental level. It was an offence to do so, with a term of imprisonment and a fine of up to $13,000 attached. Up until 2021, in order to provide certain kinds of migration advice, lawyers also had to undertake an approximately year-long course and register as what is known as migration agents. Since 2002, lawyers have been released from this dual regulation regime. The change means that run-of-the-mill lawyers can now give migration advice without additional training, as long as they have a certain kind of practicing certificate. It's a change that was welcomed by many legal professionals and aimed to simplify the system. That being said, it's really useful to know that migration agents rather than lawyers remain the most common source of migration advice for many non-citizens, and that the people who you are most likely to come in contact with as a clinician or a health professional or someone working in another sector assisting a client is probably a migration agent in the course of your work. So now what I want to do is give almost a bird's eye view of the migration program and how it operates. I'm starting this process of giving you a bit of an insight into kind of the building bricks of the migration system and program by looking at what is called the migration program or permanent program. There are a range of ways to carve up the migration program when trying to think about it and understand it, but a key division is between temporary visa classes and permanent visas. The way the department or the government approaches this is to talk about a temporary program and then what is called a migration program. The migration program is the permanent migration program. You can already see a kind of bias here. The department and the government considers the migration program as the one that involves non-temporary and permanent visas. There is an ideology here, which is worth unpacking, as a temporary program and all of the people who come to Australia as part of that program is, of course, part of the migration program. That's probably a talk for another day and with another focus. So the migration program involves the grant of some form of permanent status. Australia's migration program's total intake, excluding the humanitarian program, which I'll talk about in a moment, for 2022 to 2023 was approximately 195,000 places. So these consisted of 142,000 skilled stream places approximately, and approximately 53,000 family stream places, and a very small number of places that don't fit into these two broad categories. So you can see already in that permanent program, there are these three streams that are up on the slide. The three main contributor countries were India, China, and the Philippines. And this next slide gives you a little bit of a sense of the way in which the migration program, the numbers in the migration program pan out across those different streams. So you can also see the very noticeable COVID, the effect of COVID there, where the cross meets and then back to something that looks a little bit more normal. Very notably, 2022 to 2023 saw the largest ever delivery of the permanent skilled migration program in Australia's history. The skilled labour stream is a very significant part of the inflow of labour into Australia's economy, and all visa categories in this stream bear a heavy emphasis on the idea of filling labour shortages and a very nationalist underpinning of protecting Australian jobs in the process of filling those shortages. Following the period in which COVID-19 prevented migration to Australia, skilled migration was and is a central part of the federal government's COVID and economic recovery plan. A focus on permanent skilled visas and reforms to this area is now taking place alongside a much broader policy agenda of reducing the overall size of Australia's migration program, including limiting a number of temporary visa programs, which I'll come to later in the talk. However, for the skilled migration stream, the largest number of visas continue to be awarded to those who come under employer-nominated schemes, so they're connected to a particular employer. Those skilled migrants may also come independently if they meet the requirements to do so and have an occupation on the skilled occupation list, which changes regularly. If an occupation isn't on that list, those streams are not available to a particular applicant. Other categories in the skilled migration scheme give an important sense of how earning an income and income capacity and finances impact what is formally known as a non-discriminatory migration program, by which I mean if you meet the criteria for an application, your application will be successful, that sense of non-discrimination, but for the visa criteria. Alongside skilled labour as such, visa subclasses still include a global talent visa and business innovation and investment visas. The government, for example, is currently keen to increase the migration of high paid, not just skilled, but highly skilled professionals via the Global Talent Program. This is a fast track process to permanent residence for highly skilled migrants excelling in their field. Applicants in the Global Talent Employer Nominated Scheme, by way of example, need to demonstrate that they are highly skilled and that they earn or have the potential to earn a salary of $175,000 a year or more. Approximately 5,000 places were filled in the Global Talent Programs overall in the last financial year. Notably too, in October 2022, Ministerial Direction number 100 was released. That's as exciting as it sounds. In accordance with that direction, the department gives highest priorities of interest to this particular webinar to healthcare and teaching occupations in the skilled migration schemes. And in the last financial year, the number of registered nurses that entered under these programs were higher than any other occupation group in a skilled stream. So that was approximately 10,000 nurses that entered. So that's the skilled stream of the permanent program. The next core stream of the permanent program is the family stream, which aims to allow non-citizens and citizens and permanent residents to reunite with close members of their family and for partners to migrate to Australia. Let's go back here. Notably, by far the largest category in the family stream, and one clinicians are very likely to encounter, are partner visa applications. They make up approximately 80% of the program. The partner visa application is a long and complex affair. It involves 2 stages, a provisional stage, which allows a non-citizen to remain in Australia until they are granted a permanent partner visa. This is permitted usually after 2 years of being on a provisional visa. An ongoing and important feature of this program to note, very relevant to the partner visa, but certainly other visa categories, and particularly family visa categories, is that of delay. So in June 2023, there were over 200,000 family visa applications on hand with the department, and the wait time for a partner visa is currently anywhere between 8 and 13 months. That's the average time, with others waiting years depending on an applicant's country of origin. And I really do mean years when I say that that is the length of period of waiting for this visa category for some people. Administrative aspects of the migration process, including wait times, are a hugely significant aspect of non-citizens' experience of Australia's migration program and worth being aware of across all migration categories. Last but not least in the permanent program is the humanitarian program. This is my area of academic expertise and the field in which I research and publish, but also the least like any other category of migration. I will address it as briefly as I humanly can. The first thing to note about this program is that due to government border control rhetoric and decades-long bipartisan anti-asylum seeker policies, many people understand this program only or primarily as asylum seekers who arrive by boat without authorisation. This is, in fact, a misapprehension and one that reflects really one aspect of this program. And since successive governments have implemented a range of deterrence policies, including a boat take back and turn back policy, so boats are forcibly returned to where they came from, this program is in fact by far the smallest aspect of the program. In 2023, only 77 people arrived by boat. Less than 200 people have arrived by boat so far this year in 2024. These numbers, though, do not account for the approximately 200 people whose boats have been interdicted and they've been forcibly returned by the Australian Navy since the beginning of the Albanese government in May of 2022. So a significant element of the onshore program that doesn't involve people who arrive by boat, and once again, one that clinicians are really likely to be exposed to, involves those who arrive here lawfully onshore, that is, by plane on another visa category, or for example, on a student visa or tourist visa, and then seek asylum after arrival. This could be an asylum claim on the basis of access to healthcare or on account of living with a bloodborne virus, or indeed any other category of asylum claim. And you can see the refugee definition briefly noted there on the slide. These are also onshore asylum seekers, but they are not subject to the deterrence mechanisms and policies such as immediate detention and offshore processing because they arrive with a valid visa and were immigration cleared. The final and most numerically significant category is the offshore humanitarian program in the humanitarian stream more broadly. This covers refugees registered outside of Australia, such as those in protracted refugee situations in refugee camps, but not only those, who are referred to Australia primarily via the UNHCR or via a family member living here in Australia. Numbers range in this category each year, but it sat at about 16,000 people last year who entered Australia. You can see that on the slide as well. And only 2,000 visas were granted to onshore applicants in that same period. So it's interesting and important, I think, to note that discrepancy. Okay, that's the permanent program broadly covered. And I'll now move to the temporary program. And this will be the second and final part of the presentation. Those with temporary visas are, of course, necessarily much less secure in their status, with limited access to rights and entitlement. For example, it's worth noting that a majority of temporary visa holders do not have access to a minority of temporary visa holders, have access to Medicare, and as a general rule, they do not have access to Centrelink, housing support, or other welfare services that are available to Australia's residents and non-citizens. Temporariness is, of course, appropriate and fit for purpose for certain visa categories, such as visited visas. However, for other classes of visa holders, including those who find themselves on rolling temporary visas over many, many years, temporariness poses a range of challenges, not least accessing safe employment, secure status, healthcare, and the good fortune that many of us have, which is a knowable future. In the last financial year, quite amazingly, more than 7 million temporary visas were granted in Australia. More than half of those visas were visitor visas. And in the interest of time, I will not be going into every category of temporary visa, but from the slide, you will see the main, or get a sense of the main subclasses involved in the program: visitor student, working holiday maker, temporary skilled work as opposed to permanent, some seasonal worker schemes, and bridging visas. So this next slide gives you a sense of the largest category of temporary visa holders in Australia. And you will see here that outside of visitors, students and those on temporary skilled work visas and working holiday makers all come to Australia in very, very significant numbers, as well as a large number of bridging visa holders, which I will explain very shortly. At this point, it's useful to note for non-migration lawyers and for anyone who has not been a non-citizen in this country that there is, of course, a relationship between the temporary and the permanent program. A non-citizen may be able to move from a temporary visa to a permanent visa, and some temporary visas have explicit pathways to permanent residency. However, a theme running through Australian migration law is the increasing difficulty of acquiring permanent status for those on temporary visas. And these are challenges that I, along with other colleagues here at UTS, have analysed as a very problematic form of permanent temporariness in Australia's migration program, particularly but not only for asylum seekers who arrive by boat and continue to be punished for that mode of arrival. Even though it may seem that migrants and non-citizens come to Australia on a particular visa and remain on that visa, there is actually substantial movement across visa classes, and the Productivity Commission recently found that even migrants transitioning from a temporary to a permanent visas are granted on average 3.3 visas during their time in Australia. For those on temporary visas with work rights, there is a growing awareness of the fact of extreme and systematic exploitation at work of this group. This is a huge current issue and certainly one for temporary visa holders. There are major and I think underexplored health impacts of such exploitation and the challenges of addressing it, given temporary workers' vulnerability to their employers, especially if they are employer-sponsored and don't feel at liberty or are not supported to report any kind of harms at work. On this front, earlier this year, so in 2024, a national coalition of over 40 community legal centres, unions and human rights organisations successfully advocated for the federal introduction of a groundbreaking workplace justice visa. This visa will enable exploited migrants to remain in Australia on a further visa if they are seeking to enforce their workplace rights or to hold employers to account for labour violations and modern slavery that they have experienced. This was not something that was open to temporary visa holders whose visa holders might in the past have run out. They would be required to leave Australia and they would have no access to justice for any of the exploitation they suffered at work. The visa is a world first. It reflects years of campaigning and research by migrant workers, as well as by the Migrant Justice Institute at UNSW. Finally, in the context of thinking about both procedural aspects of migration law and the experience of applying for a visa, I wanted to highlight one last temporary visa category, which is the bridging visa category, of which there are many subclasses that I won't be going into. While these are meant to be very short-term visas, and their purpose is to allow for the regularisation of status while someone's visa application is being finalised. So while you have an application on foot with the department, you might get a bridging visa while that application is being considered if you're transitioning between visas. They are also granted to people whose visas have been cancelled or lapsed for a discrete period of time while removal or departure from Australia is facilitated. They are often treated as insignificant or merely procedural aspects of Australian law, though a range of recent media reporting has actually kind of challenged that view. Again, you can see from this slide, up until March 2024, there are actually extremely large numbers of people in Australia on bridging visas, and these visas come with major challenges regarding access to work, to healthcare, to Medicare specifically, and to other general welfare rights. That brings us to the end of the overview of Australia's migration program, and I just want to conclude by going over a little bit of information about short and medium-term policy that will be significant in this area in the coming period. So many people might have noticed that the federal Labor government has planned for Australia's intake of migrants to be cut sharply, approximately and staggeringly halving it in the next 2 years. This is a part of a broader overhaul of Australia's migration system. The opposition is proposing sharper cuts still. Certain visa categories will be affected more than others, and listeners will have already, or may have already, seen that international student visas are one of the major and controversial areas for reform. Although contested, the government has linked planned reduction to the need to manage things like inflation, cost of living pressures, and housing shortages. Notably, and linking to a key theme in today's presentation, a lot of these cuts will be made in the temporary, not the permanent migration program. A positive aspect of other reforms on foot at the moment is a genuine aim to address backlogs that characterise migration processing and procedure. These are backlogs that people coming into contact with the migration program, not as migration professionals, but as assisting clients in other capacities, will absolutely come into contact with. Some of these reforms include the introduction of a new administrative review tribunal. However, it is yet to be seen how effective these reforms are in addressing what is one of the most difficult aspects of migration law and the program in Australia, which is delay and unpredictability in migration processing. While there has been much debate about whether crude attempts to cut or reduce migration levels will achieve the government's stated policy objective, I'll end with reflecting on the importance of not seeing the migration program and the people within it as simply a means to a policy end in a dehumanised manner or in service of Australia's economy or prosperity. Migrants are members of the community, they're our friends, they're our families, and as the Chief Executive of the Settlement Council of Australia, Caroline Elhew noted in regards to these debates more recently, that migration is more than just a number, and that the quality of the settlement experience and the experience of those coming to Australia is often overlooked in discussions of the migration program in an abstract and overly quantitative way. And with that, I will hand back over to David and then to Vikas, who will take us through the health requirements that attach to many of the visa categories that I've just mentioned.
Thank you, Anthea. As ever, complex, ever-changing and really difficult area, both to provide an overview of, but as well, of course, for individuals, their families and clinicians to be able to navigate. So thank you so much. Our next speaker is a colleague also from Health+Law, Vikas Pawani. Vikas is the Principal Solicitor of the HIV/AIDS Legal Centre, known as HALC, here in Sydney. Vic received his Juris Doctor from the University of New South Wales, right here, and has published and presented legal information and research on HIV and the law in Australia, as well as in international contexts. Of relevance particularly, I think today, is that Vic is an accredited specialist in immigration law and has briefed in test cases before the full Federal Court of Australia. All of this expertise and experience comes together for Vic in a way which means he is particularly interested in and committed to understanding the power of law to improve harm reduction and to improve access to justice for marginalised communities. Vic is going to present today in a little bit more detail about the process of migration law and its working for people, particularly living with and affected by hepatitis B. Thank you, Vic.
Thank you, David, for that fantastic introduction, and thank you, Anthea, for that great overview of the Australian migration system. I'm just going to share my screen as well. Bear with me for a second. Right. So I'm going to start off by talking a little bit about the service that I'm from. The HIV/AIDS Legal Centre is a not-for-profit specialist community legal centre that represents people with HIV and hepatitis-related legal problems. We also do law reform and community legal education in that space, and have publications and guides to HIV and the law. Going back to what Anthea was talking about earlier in terms of the various visa requirements and criteria, I'm going to talk about one very specific criteria, which is the health requirement for visas. Now, all visas to Australia are subject to health criteria, temporary or permanent. Now, in the temporary space, or whether you're in the permanent space, you will be required to undergo or ask questions, answer questions about the health of the applicant and any dependents on that application, and they'll then have to potentially undergo a health examination. So not all visas require a health examination, but where an applicant discloses that they've got a health condition such as hepatitis, usually this is required. So for temporary visas, if a person has hepatitis B and they intend to study, train, or work as a doctor, dentist, nurse, or paramedic, or if a person is pregnant and intending on giving birth in Australia, they'll be required to do a health examination. There'll be a question on the form that asks about your health, and then that might result in you having to undergo a health examination. For permanent visa applications, there isn't a question per se on the form about your health, but there's a requirement that there's a health examination, which includes a test for hepatitis and other illnesses and bloodborne viruses. Now, what happens when a person does have a health condition that might impact their visa is that the results of that health examination are sent to a person that's known as the medical officer of the Commonwealth, who will then produce a costing of that person's health over the term of the visa. For a temporary visa, that's for the length of the visa. So if you've got a 3 or 5 year student visa, it'll be for that length. Or if it's a 6-month visitor visa, it'll be for the length of that visa. Now, the assessment of that health requirement and of the particular condition that you're being assessed for will depend on there's some notes for guidance and some policy which dictates whether a person will meet the criteria or not meet the criteria. And I'll go through a little bit about what that means shortly. It's important to note that there are some visas that require that you meet the criteria. So if a person doesn't satisfy the health criteria, they don't get the visa. However, there are some visas where there's some provision to have those requirements waived. And I'll be talking a little bit about that shortly as well. So generally, as I said previously, that for a temporary visa, a person's assessed for the length of the visa. But for a permanent visa for hepatitis B currently, the costs of a person's health are assessed over a 10-year period. So now anything over $86,000 is considered a significant cost, which means they don't meet the health criteria for the visa. For hepatitis B, the cost has recently substantially decreased because of the decrease in the cost of treatment for hepatitis. So it's quite a substantial reduction. So it used to be $2,330 for just the medication per year. And it's now fallen to $632. And including the other costs like medical appointments, and the cost of tests, the total cost has now decreased from $3,906 a year to now $1,259 a year in the most recent notes for guidance. What that means is that for temporary visas or for permanent visas, a person with hepatitis who's on treatment should be able to meet the health requirement both for temporary visas and for permanent visas. So if we calculate based on the current amount, for a permanent visa, which is calculated for a 10-year period, you're looking at a costing of somewhere around $13,000 approximately, which falls below that threshold I referred to previously of $86,000. So the good news is that a person with hepatitis B usually will be able to meet the criteria for both temporary visas as well as permanent visas. Now, there are situations where a person with hepatitis B who's got advanced stage liver disease may not be able to meet the criteria. So that's for 2 reasons. So there's generally in the health criteria, there's a couple of considerations. One is the cost that I've just discussed not long ago, but the other consideration is whether providing medical treatment to a person will impact on the ability of other Australian citizens and permanent residents to be able to access that treatment. And so that's where the liver disease comes into play, where if someone requires an organ transplant, now that's listed as something that might prejudice access to a transplant to an Australian citizen or permanent resident who might otherwise require one. So where there is liver disease and a transplant is required, it means that a person could fail the health criteria, potentially not just for crossing that significant cost threshold, because the cost of that transplant might or may well exceed that $86,000 amount that I referred to, but also that transplant could then prejudice access to Australian citizens and permanent residents. So when that situation occurs, a person will not meet the health criteria, and they'd have to seek a visa which allows for a waiver of those requirements, and that's known as a health waiver. Now, for seeking a waiver on the costs of a person's treatment, a person will have to demonstrate where there's a waiver available that their health would not cause undue costs to the Australian community. Now, the word undue isn't defined in the law. It's given its ordinary meaning, which means unwarranted or excessive in the circumstances. But there's a set of factors under policy and from case law that have developed and the department applies them in determining whether the cost of someone's health will be undue or not. And those are whether they've got ability to mitigate the costs of their health or whether there are any compelling and compassionate factors in their case. No, there's a whole list of factors listed in policy about the waiver. I'm not going to go into them at the moment, but the thing to note from that is that there must be documentary evidence of a person's ability to mitigate costs or compelling and compassionate factors. That's very clearly listed in policy. So if there's any claims that are being made about the compassionate factors that that should be considered in the case of any particular applicant or visa sponsor, then they should accompany some documentary evidence. In relation to a waiver on the grounds of prejudice to access, there's a few considerations which are on this slide. So whether that an organ donation could be available from a family member, or if there's evidence that suggests that that person might not require a transplant. So those are situations where a waiver might be granted on that prejudice to access ground. Now, if you recall, Anthea went through the various streams of the migration program in Australia. There's limited permanent visas that allow for a waiver. So there's certain family-sponsored visas like partner visas and child visas that allow for that the requirements to be waived. The skilled visas pathway, it gets a bit harder. You have to either commence from an employer-sponsored temporary visa pathway, which then leads to a permanent one, or that global talent visa that Anthea was talking about before, that also has a health waiver available. There's a new visa for people who from the Pacific who belong to certain islands in the Pacific, which if they put an expression of interest for that visa, they can be invited to apply. There's a quota for that yearly that also has a health waiver. So the requirements are limited, but as I said, for most people with hepatitis B, they won't require a waiver, and they should be able to meet the health criteria outright because of the costs of the treatment, as long as they don't require a liver transplant. Now, this slide it's basically some best practices, and you normally see people from cult backgrounds impacted by health and the visa requirements and the complexities around the health criteria. So it's really important that I guess a lot of the complications may arise for people with hepatitis B where they haven't disclosed their status when asked a specific question in the visa application. They might arise at a later point where if they've been newly diagnosed or if they've recently commenced treatment or if they've progressed to a point where they require a liver transplant. They may also then have issues in relation to when they haven't disclosed to a migration agent or a lawyer that they've got a health condition which might impact their visa because they weren't aware. So there's a few areas where we often see where applicants will trip up and then they need tailored specialized advice to deal with those situations. So one of the other ones that we often see are missing deadlines or due dates. There's very strict limitation periods that can apply in visa applications to appeal decisions or to respond to requests from immigration, which if they don't do in time, then those options become closed. So these are just some tips that I'd suggest all people who apply for visas be just aware of so that they don't fall into traps to have visas refused on character grounds for not being truthful on applications, or just when they don't or can't meet the criteria for a visa because of their health condition. Clinicians should look out for those situations that I've mentioned and refer people to the HIV/AIDS Legal Center or another immigration lawyer for advice, particularly when some of these situations arise. So where someone's newly diagnosed, where someone's recently commenced treatment or have advanced liver disease and may require a transplant. So what we suggest is that anyone going through this migration pathway should seek advice early and often, even just in relation to if it's a skilled pathway that someone might be looking to progress towards. What skills are in demand in Australia? Do they lead to a visa which has a waiver, or where which is even a skill that leads to employer sponsorship perhaps, or an invitation to apply where a waiver isn't required? So yeah, that would be my biggest takeaway, is to make sure that clinicians refer clients who've been through any of these situations. Now, another way that clinicians can assist clients and lawyers who are acting for clients in these visa applications is at two stages. The first stage really is often when a person can't meet the criteria for a visa because of their health condition, they'll be issued a letter, or what we call a natural justice letter from immigration, which says they don't meet the health criteria, and they might be asked to comment on that. So there is some provision for the provision of specialist reports to address or to challenge that costing that says that a person doesn't meet the health criteria, with very little success often. So it's usually if a person meets the criteria, if a person doesn't meet the criteria because of their health, then they would need a waiver. So it might not reduce the costing, but it can be helpful for the purpose of the waiver. And there's other ways that clinicians can provide support in terms of letters that support any compelling and compassionate factors that an applicant might be raising, any social supports they receive, perhaps even just sort of providing confirmation of any claims or fears that they might have of returning and what's been reported to them. So at those stages, letters of support from clinicians can be quite helpful. Now, I would have started this presentation with the same caveat that Anthea had, which is that this presentation is not substitute for legal advice. It's just information. So if you do need advice about your particular circumstances, that it's important that you get some from an immigration lawyer. Thank you.
Thank you, Vic, so much for that. A beautiful and succinct overview, of course, with the classic legal warning that we all like to give whenever we present, so I appreciate it. We have some other webinars coming up where there'll be an opportunity to have a more detailed discussion about the experience of migrating for people living with hepatitis B and their families and loved ones, particularly from the perspective of community members. But I suppose I wanted just to end our conversation today with a couple of broad questions, one to you, Anthea, and one to you, Vic, and please, of course, feel free to add anything you'd like at this point. Anthea, I think the thing that is really clear from your presentation is that change in migration law in Australia and in migration policy is swift, it's complex, it's seemingly constant, it's confusing. all of those epithets. And, you know, you said that this can mean that people are left in forms of permanent temporariness, and there are health impacts, of course, that this generates for people. And this is something that we're all working together to understand and support people with through our work at Health+Law. But given all of this, for the clinicians, the peer workers and others who support people living with hepatitis B who are going through a migration process, how are they meant to stay up to date with these waves of change? I suppose, is it even possible?
Yeah, it's a great question. Thank you, David. And thanks, Vikas, for such a great overview of the health requirement and waiver. Look, it's really difficult to stay up to date. It's very difficult for migration agents and lawyers who even work in a particular field to stay up to date with what might be going on in another visa subclass or another part of the program. I think being aware of that is a really important place to depart from. And I'd really echo Vikas's comments about being aware of people's migration status as such. So always inquiring, because it's not necessarily something that might be at the forefront of an interaction, that might be based on something else, health, housing, any number of things we require in our day-to-day life. So being aware of migration status. And then I would say that willingness and readiness to make referrals and inquire and support clients and people you're coming into contact with on the basis of how they're living with a particular health condition might affect their migration process and where they're up to within it. You know, I think, David and I work together on the Health+Law project alongside Vikas. And, you know, one of the things that we found again and again in talking to people is the incredible role played by health and allied health professionals in referring people to legal advice. Because the other thing, the migration program isn't just a difficult, complicated thing. Knowing where to get advice is difficult and complicated. So, you know, it's another hurdle. So being informed about those referral processes and being really aware of and willing and kind of, I guess, energetic and enthusiastic about referral and seeking information where you might feel unsure, I think is really important. Because as with any really complex legal or indeed other system, you know, misinformation is rife, and it's good to be really willing to kind of go, oh, I'm not sure what's happened, I'm not up to date on that, and knowing who to ask in those particular circumstances. Yeah.
Thanks, Anthea. Yeah, look, and that actually beautifully leads to my question for you, Vic. People we've spoken to as part of Health+Law who are living with hepatitis B really have a difficult and prolonged and protracted time getting through the various pathways and visa changes and things in relation to migration, and that's really clear. There's been a major change that I think is worth just highlighting again, which you mentioned, which is a change to two things: the lowering of cost of hepatitis B treatment in particular, but also the raising of the significant cost threshold. Because, as Anthea said, this is a complex and changing dynamic space. There's obviously a lot of information on the internet, through networks, etc., about the health requirement and how it works. But there has been this major change. So I just wanted to come back to that for a second. And maybe if you could just sort of talk about what, for most people living with Hep B, it looked like before this change, and what it kind of looks like, we think, for most people living with hepatitis B now. I think that'd help people, if they've got that old information, to be able to kind of just triangulate where they're sitting today.
Yes, of course, that's a great question, David. I suppose I'm taken back to a particular client who's very, very highly skilled, who'd come to us after being refused an employer-sponsored visa that didn't allow for a waiver. And they were on treatment and were unable to meet the health criteria for that particular visa, which is a permanent visa. And that's not an unfamiliar path for many people with Hep B prior to these changes, which is that they've applied for a visa and had a visa refused, and then have to navigate the next steps based on either advice that they were given previously, which wasn't correct advice, or that they weren't on treatment, or they just hadn't been diagnosed. So when you don't have that information and that appropriate advice, you can go down a path that is really hard to recover from in the system we have. So if a person has had their visa refused on shore, that that really limits their options of applying for other types of visas. So they're barred by statute on applying for certain types of visas. So it's really, really important to get advice early, because if you have that visa refused because you were giving incorrect advice or you applied for the wrong visa, it's hard to sometimes turn back from that and go to a different pathway. For that particular applicant, they were very, very highly skilled, and we were then able to progress to seeking intervention from the minister personally to get them a visa because of their skills and the fact that them breaching that cost threshold was of such a small difference between what the threshold was and what they were found or what their costing was for their treatment. So I guess the short answer to that question is, for permanent visas, you'd get a do not meet health assessment at the end under the previous threshold and the previous costing, which would then mean that you don't meet the health criteria for the visa, and you're only eligible for visas that have a waiver. Thankfully, due to both the raising of the significant cost threshold and the reduction of the cost of the medication, that's no longer the case for temporary or permanent visas for people with hepatitis B.
And this sounds like good news for most people
Yes.
living with hepatitis B who are here. And we should note that differs for those who are living with HIV, where indeed almost everyone will breach the significant cost threshold and have to go through this waiver process still. So information that is out there, either in community networks or on the internet, that relates to the old regime in relation to hepatitis B needs to be updated and rethought given this change. And of course, information about other conditions, including HIV, now is quite different for the different situation for people living with hepatitis B. Yeah. Anthea? Yeah.
Yeah, I had a question for, I guess it is for Vikas, and something that might be useful for us to discuss. For people who have an application in train, and the date of the application might have predated the changes that have come in, what's the circumstance there? Are the changes only prospective for visa applications that were put in after a certain date? If your visa is in process, how will those changes impact?
Yeah, that's a great question, Anthea. So fortunately, the health requirement is a time of decision criteria, and it's usually something that's assessed the last once an applicant has been assessed for all other criteria for the visa. So the policy applies as per the date of the particular opinion of the medical officer of the Commonwealth. So it's from that date.
But again, hopefully good news for people who have a visa in process and various processes in process. If they haven't yet had that opinion, then the new policy applies, and this higher cost threshold is hopefully going to support many people living with hepatitis B to move through this process.
Yeah, and a great moment to seek contact with your lawyer or your migration agent if your application is in train and you're not sure if you've gotten that opinion yet, or just to check in with where the changes are.
Agreed. Well, thank you both, Vikas and Anthea, for being here today in the webinar. I know that there will be many questions that will come up from clinicians and peer workers and others who work with community members to support them during this period of migration, also from community members too, of course. And so we encourage those questions to be sent along if you are viewing this webinar, and we have others coming up where we'll try and collect those and respond to them in a way we hope that is helpful for community members and other workers as well who are in this space. So thank you again, Anthea. Thank you, Vic. We really appreciate your time, and we'll see everyone here one of our other webinars, which you can learn about at our website, which is www.health+law.org. Thanks very much.